On December 6, 2000, a seemingly ordinary day in East Texas would mark the beginning of one of the most extensive and disturbing child exploitation investigations in American history. That Thursday, Mark Bates, a 32-year-old unemployed truck driver living in the rural community near Palestine, Texas, approximately 100 miles southeast of Dallas, sat before his computer screen in Anderson County. The air was cool, the kind of December weather that brought early darkness to the pine forests of East Texas, but Bates was focused on something far darker than the approaching winter evening. He logged into a free internet service called eGroups, a platform that allowed individuals with similar interests to create online communities where they could share information, exchange files, and communicate through the World Wide Web. What Bates created that day, however, would have nothing to do with legitimate interests or benign hobbies. Bates had been living with his parents in the Athens area after a truck accident in 1999 had left him struggling to regain employment. His mother would later tell reporters that life had been difficult for her son, that he'd had a hard time finding work after the accident. But on this particular December evening, Bates had a different kind of work in mind. He began setting up an online group, carefully typing out the description that would appear on its main page, choosing words that would seem innocuous to casual observers, but would carry an unmistakable meaning to those who understood the coded language of online predators. He named his creation the Candyman Group, a reference that would later be associated with the beloved song from the 1971 children's movie Willy Wonka and the Chocolate Factory, a grotesque appropriation of childhood innocence for the most sinister of purposes. The main webpage of the Candyman Group announced its stated purpose with deceptive simplicity. The text read, in deliberately casual language with intentional spelling errors that gave it an informal, welcoming tone. This group is for people who love kids. You can post any type of messages you like to, or any type of pics and vids you like to. P.S. If we all work together, we will have the best group on the net. To anyone unfamiliar with the dark corners of the internet, this might have seemed like a harmless parent support group or a community for those who worked with children. But the phrasing "love kids," combined with the invitation to post any type of pics and vids, carried a meaning well understood in the underground networks of child exploitation. Within the organized structure of eGroups categories, Bates had deliberately placed Candyman in the adult transgender image gallery section, a classification that immediately suggested sexual content to those browsing the platform. Bates assumed the role of moderator, the administrator who would control access to the group and manage its operations. He used the email address thecandyman31 for his administrative functions, though he also employed the alias lover of pictures in various online contexts. The Candyman Group was structured with several features designed to facilitate its true purpose. There was a files section where members could upload and post images or video files for others to download. There was a polls section that allowed group members to participate in surveys, asking questions about preferences and interests. There was a links section where members could share website addresses directing others to similar content elsewhere on the internet. And there was a chat section enabling members to engage in real-time conversations with one another, presumably to coordinate their activities and share information about their collections. From the very beginning, Bates designed the Candyman Group as more than a passive repository for illegal material. He actively recruited members, sending out invitations and welcoming messages. He distributed surveys to subscribers, asking detailed questions about their preferences. Did they want to see more images of boys or girls? What age ranges interested them most? Do they prefer what he termed more actions, or soft pics, using euphemistic language to categorize different types of exploitation material by severity? This was not the work of someone who had stumbled into illegal activity by accident. This was the careful, methodical construction of a criminal enterprise, designed to grow and to serve an international community of individuals who shared Bates's predatory interests. As December turned to January in the year 2001, the Candyman Group began to attract subscribers. At the time, eGroups operated as a free service owned and run by a business entity of the same name, Joining a group was simple. A person needed only to visit the Uniform Resource Locator, the web address, and send an email to the group moderator requesting permission to join. The moderator would then send a confirmation notice to the requester's email account, advising them that they now had access to the group. Once admitted, all new members were immediately added to the Candyman email list. According to the way the platform was initially understood to function, every email sent to the group would be distributed to every member automatically. This meant that when an individual uploaded and transmitted child pornography to the Candyman group, those images would be transmitted to every one of the group members, creating a vast distribution network that operated with frightening efficiency. The subscription process appeared straightforward, but it required intentional action. Nobody could accidentally become a member of the Candyman group. They had to seek it out, request access, confirm their membership, and then choose to remain subscribed. Every member was given clear instructions for canceling their membership if they wished to do so. The act of joining and remaining in the group was voluntary, deliberate, and indicative of intent. Throughout late December of 2000 and the early weeks of January 2001, Bates's creation began to grow, spreading through networks of online predators like a malignant growth, connecting individuals across cities, states, and eventually nations, all united by their shared interest in the exploitation of children. On January 2, 2001, more than 1,500 miles away from East Texas in the Houston Division of the Federal Bureau of Investigation, Special Agent Jeffrey Binney made a decision that would ultimately bring the Candyman operation crashing down. Working in an undercover capacity as part of the FBI's ongoing efforts to combat child exploitation on the internet, Agent Binney had been monitoring various online groups and forums known to facilitate illegal activity. On this Tuesday morning, Binney subscribed to the Candyman e-group, providing an email address and following the same process that any other prospective member would use. Within moments of his subscription being confirmed, Binney gained access to the group's features and began receiving the stream of communications that flowed through the network. What Agent Binney discovered immediately was deeply disturbing. The files section of the website contained a collection of images and video clips that members had uploaded for others to download. Binney methodically began capturing and cataloging this material as evidence. Over the course of his investigation, he would capture approximately 100 images and video clips that had been uploaded to the Candyman website. These files depicted prepubescent minors engaged in various sexual activities, showed close-up views of the genitalia of nude minors, and included what law enforcement categorized as child erotica, sexualized images of children that might not meet the strict legal definition of pornography, but were clearly created and collected for sexual purposes. The images showed children in positions and contexts that no child should ever be subjected to, documentation of abuse that represented real victims, real trauma, real crimes that had been committed against vulnerable young people. But the files section is only part of the picture. Almost immediately after joining the group, Agent Binney began receiving emails addressed to the Candyman group from other members. These emails arrived with alarming frequency, and many contained attached images of child pornography or child erotica, or they contained information concerning those subjects or details about the operation of the group itself. The emails represented an active, ongoing distribution system, with members constantly sharing material with one another, trading images like commodities, treating the sexual exploitation of children as a hobby to be pursued and a collection to be built. From January 2, 2001 through February 6, 2001, a period of just over 1 month, Special Agent Binney received approximately 498 email messages from the Candyman e-group. The volume was staggering, averaging more than 15 emails per day, every single day, for 5 weeks straight. Out of those nearly 500 emails, Binney received a total of approximately 183 child erotica images and 105 child pornography images through these communications. This meant that roughly 300 images of exploited children flowed through this single distribution channel in just over a month, and this was only what one member received. With thousands of members in the group, the total volume of material being distributed was almost incomprehensible. As Agent Binney monitored the group's activities, He also observed the polls and surveys that moderator Mark Bates distributed to members. These surveys asked members to vote on their preferences, essentially conducting market research to determine what kind of content the group's subscribers wanted to see more of. The cold, business-like approach to such horrific subject matter was chilling in its implications. This was not impulsive behavior or the actions of individuals struggling with mental health issues who accidentally stumbled into illegal activity. This was organized, systematic, and collaborative. Members discussed their shared interests openly within the group, offered suggestions to one another, and even provided technical advice on how to better hide their activities from law enforcement detection. In mid-January 2001, Agent Binney reached a critical juncture in his investigation. He had gathered substantial evidence about the operation and structure of the Candyman Group, but to proceed further with prosecution, he would need to identify the actual individuals behind the email addresses, to connect screen names and online handles to real names, real addresses, real people who could be arrested, charged, and brought to justice. On January 19, 2001, Binney contacted Yahoo, the company that had recently acquired e-groups in late January of that year, just as the FBI investigation was beginning. Yahoo now owned and operated the platform on which the Candyman Group existed. When Binney identified himself as an FBI agent investigating child pornography and requested information about the Candyman Group and its members, the response from Yahoo's representative was unexpected and frustrating. The representative refused to answer Agent Binney's questions, declining to provide any information about the group's operation or subscriber list. This lack of cooperation meant that Binney would need to pursue a more formal legal route. On January 19, 2001, the same day he made his initial contact with Yahoo, Agent Binney obtained a federal subpoena directing Yahoo to divulge information regarding the members of the e-groups under investigation, specifically including the Candyman Group. Meanwhile, Agent Binney asked Yahoo to keep the Candyman site running so that the investigation could continue, so that the FBI could gather more evidence and fully map out the extent of the network before shutting it down. This was standard procedure in large-scale investigations, allowing the operation to continue under surveillance for a period of time to ensure that investigators could identify as many participants as possible before making arrests. However, Yahoo ignored this request, making the independent decision to shut down the Candyman e-group unilaterally. On February 6, 2001, Yahoo terminated the Candyman Group's access to its platform, shutting down the website after it had operated for exactly 2 months. Along with this shutdown, Yahoo complied with the federal subpoena and provided the FBI with a list of email addresses for the group's members. The numbers were staggering. The Candyman Group had attracted approximately 7,000 subscribers from around the world, with around 2,400 of these subscribers living outside the United States in countries across Europe, Asia, and other continents. This meant that roughly 4,700 members were based in the United States alone, scattered across all 50 states, representing a cross-section of American society that would prove shocking in its diversity. With the list of approximately 3,397 members' email addresses in hand, the FBI now faced the massive task of identifying who these people actually were. Email addresses alone wouldn't be enough for prosecution. The FBI needed names, physical addresses, phone numbers, and evidence that could be seized from the homes and in computers of the subscribers. Binney and his team began issuing subpoenas to email service providers, requesting identifying information for the accounts associated with each email address on the Candyman member list. America Online, Hotmail, and dozens of other internet service providers received these subpoenas and provided the requested information. As the responses came back, a clearer picture began to emerge of just who had been participating in the Candyman Group. The FBI compiled dossiers on thousands of individuals, methodically building cases that could be prosecuted. To assist local FBI field offices around the country with their investigations, Agent Binney provided a template for a search warrant affidavit containing general information obtained during the course of his investigation into the Candyman Group. This template would be adapted by agents in various cities as they pursued suspects in their jurisdictions. The FBI transmitted the identifying information to all 56 of its field offices around the nation, assigning each office to investigate individual members who lived in their areas of jurisdiction as part of a coordinated national investigation that would eventually be given an official designation. Throughout the spring, summer, and fall of 2001, FBI agents across the United States worked quietly, building cases against Candyman subscribers. They verified addresses, confirmed identities, gathered additional evidence through surveillance and online monitoring, and prepared search warrant applications. The investigation required patience and meticulous attention to detail. Each case had to be solid enough to withstand court scrutiny, especially given the Fourth Amendment protections against unreasonable searches and seizures. Agents had to establish probable cause that each individual suspect had not merely stum-ribed upon the Candyman group by accident, but had actively participated in receiving and possessing illegal material. By late 2001 and early 2002, the investigation had matured to the point where coordinated action could be taken. In Houston, Texas, federal prosecutors in the Southern District began preparing indictments against Mark Bates and several of the Texas-based subscribers. The evidence against Bates was overwhelming. Not only had he founded and operated the group, but investigators had traced the Candyman 31 email address to an America Online subscriber who also used the name Lover of Pictures, and the AOL subscription was paid for with a credit card billed directly to Bates's address in Anderson County. When the FBI learned more about Bates's background, the case took on even darker dimensions. Records showed that Bates had 2 prior convictions for child molestation. He had a documented history of sexual offenses against minors, which made his creation and operation of an international child pornography distribution network all the more disturbing. On November 30th, 2001, Special Agent Michael Millard, working out of the FBI's Houston office, led a team of federal agents and local police officers to execute one of the first search warrants in what would become Operation Candyman. The target was Robert Froman, a 49-year-old man who managed a bunkhouse in Pasadena, Texas, a city just southeast of Houston. Froman had subscribed to the Candyman group on January 9, 2001, using the email address fbunkhousebob@aol.com. Through a subpoena to America Online, the FBI had discovered Froman's address, phone number, and billing information, which had ultimately tracked him to the bunkhouse he managed. AOL records also revealed alias screen names that Froman used, including Little Butsu and Little Tit Girly, names that strongly suggested sexual interest in children. When agents executed the search warrant at Froman's residence, they discovered substantial evidence on his computers and in hard copy printouts. The computers contained images of child pornography, matching images that had been posted to the Candyman e-group, proving that Froman had not merely received the material automatically, but had actively saved and retained it. Even more disturbing, agents found images of a minor girl performing sexual acts, and later investigation would reveal that Froman had himself produced child sexual abuse material involving a relative who was a minor. The evidence seized from Froman's bunkhouse would eventually lead to his prosecution on federal charges of transporting, distributing, and receiving child pornography via the internet, as well as state charges for aggravated sexual assault of a child. Throughout December 2001 and January 2002, FBI agents continued executing search warrants across Texas and other states. In St. Louis, Missouri, agents searched the home of Gregory Strausser, a 51-year-old resident of the Millville area in the 5700 block of Huntington Valley Court. The search, conducted on January 17, 2002, uncovered a compact disc with a file on it named Candyman. When Agent Ann Pancoast interviewed Strausser and asked him how much child pornography he possessed, Strausser reportedly responded, "Thousands of images." The searches were producing results across the country, with computer hard drives, disks, and storage devices being seized and sent to forensic specialists for examination. But even as these searches progressed, problems began emerging with the investigation's foundational evidence. The template search warrant affidavit that Agent Binney had created stated clearly that every email sent to the group was distributed to every member automatically. This assertion formed a crucial part of establishing probable cause for the searches. if subscribers automatically received all emails containing child pornography simply by being members of the group, then membership itself was strong evidence of possession of illegal material. However, defense attorneys beginning to review the cases in early 2002 started raising questions about this claim. On March 18, 2002, the culmination of Operation Candyman's first phase burst into public view in a coordinated announcement that sent shockwaves across the nation. At a press conference held at FBI headquarters in Washington, D.C., Attorney General John Ashcroft stood before assembled reporters and cameras to unveil one of the largest child pornography investigations in American history. Beside him was Bruce J. Gebhardt, the FBI's Executive Assistant Director for Criminal Investigations and Cybercrime, ready to provide details about the scope and significance of the operation. It is clear that a new marketplace for child pornography has emerged in the dark corners of cyberspace, Attorney General Ashcroft told the assembled media. However, he added with emphasis, the arrests prove there will be no free rides on the internet for traffickers of child pornography. The announcement was stunning in its implications. The FBI revealed that its Operation Candyman sweep had already resulted in criminal charges against more than 89 people in 26 states. But this was only the beginning. Gebhardt announced that the FBI expected to arrest at least 50 more people by week's end, with additional arrests anticipated in the coming months as the investigation continued to expand. The details that emerged about those arrested were particularly disturbing because of who they were. Among the 89 people charged were 2 Catholic priests, one in the St. Louis area and another in Baltimore. 6 other members of the clergy from various denominations had been arrested. Also charged were a school bus driver in Albany, New York, a preschool teacher's aide in Las Vegas, a teacher in Constable, New York, a child photographer in Philadelphia, another unspecified clergy member in Philadelphia, and a police officer, whom some reports identified as being from Pittsburgh, while others mentioned West Virginia. The list also included Little League coaches, a guidance counselor, a nurse, a foster parent, a mentor from Big Brothers Big Sisters, and military personnel including a United States Army sergeant. These were individuals who held positions of trust and authority in their communities, people who had regular access to children through their professions and volunteer activities. The geographic spread was equally disturbing. Arrests had been made in states from coast to coast: California, Connecticut, Florida, Georgia, Illinois, Indiana, Kansas, Louisiana, Maryland, Massachusetts, Michigan, Missouri, Nevada, New Jersey, New York, North Carolina, Ohio, Oklahoma, Oregon, Pennsylvania, Tennessee, Texas, Utah, Vermont, Virginia, and West Virginia. No region of the country had been spared. The Candyman group had attracted members from major metropolitan areas and small rural towns alike, demonstrating that this form of criminal activity transcended geographic, economic, and social boundaries. Attorney General Ashcroft emphasized the severity of the crimes involved. This operation represents a significant step forward in the Department of Justice's commitment to protecting America's children, he stated. These individuals use the anonymity of the internet to victimize children. We will use the full force of the law and the resources of the Department of Justice and its component agencies to bring them to justice. The Attorney General revealed that some of the arrested individuals had not merely consumed child pornography, but had actually produced it themselves, creating new material by sexually abusing children who were in their care or whom they had access to through their work or community positions. FBI Executive Assistant Director Gebhardt provided additional context about the investigation's origins and methodology. He explained that the Bureau had been monitoring various online groups known to traffic in illegal material, and that the Candyman group stood out because of its size, organization, and the volume of material being distributed. What made this group particularly dangerous, Gebhardt explained, was not just the number of members, but how actively they participated in sharing material and recruiting new members. This was a community of offenders who enabled and encouraged each other's criminal behavior. When reporters asked about the technical details of how the investigation had proceeded, Gebhardt declined to provide specifics, citing ongoing investigative techniques that the FBI did not want to reveal to other criminals who might be operating similar networks. However, He did confirm that the investigation had required extensive cooperation from internet service providers, and it involved issuing hundreds of subpoenas to trace email addresses back to physical addresses and real identities. The massive scope of the data analysis required had pushed FBI resources to their limits, with computer forensic specialists working around the clock to examine seized hard drives and storage devices. The press conference also addressed international cooperation. While the bulk of the arrests announced on March 18, 2002 were domestic, Gebhardt revealed that the FBI had shared information about foreign subscribers with law enforcement agencies in other countries through Interpol and other international law enforcement coordination mechanisms. Child exploitation is a global problem that requires global cooperation, Gebhardt stated. We have provided information to our counterparts in dozens of countries, and we know that investigations are proceeding in many of those jurisdictions as well. In the days following the March 18th announcement, additional details began emerging in local news coverage across the country as individual arrests became public. In St. Louis, the Post-Dispatch reported extensively on the arrest of Gregory Strausser, the 51-year-old man whose home had been searched in January. Strausser was charged with 3 counts of possessing child pornography after the search of his residence uncovered thousands of illegal images on his computers and storage media. According to court documents filed in the Eastern District of Missouri, Strausser had been a member of the Candyman Group from January 2001 through its shutdown in February 2001, and during that time had received numerous emails containing attached images of child pornography. The newspaper's coverage included statements from neighbors who expressed shock and disbelief. Strausser had lived in the quiet Mealville neighborhood for years, was known to keep to himself, and had never given any outward indication that he was involved in criminal activity. He seemed like a normal, quiet guy, one neighbor told reporters. You never know what people are really doing behind closed doors. This sentiment would be echoed in communities across the nation as news of local arrests spread. The cognitive dissonance was profound. How could a teacher, a coach, a priest, or a police officer be involved in such heinous crimes? In Texas, multiple arrests drew significant media attention. The Houston Chronicle reported on the case of Robert Froman, the bunkhouse manager whose home had been searched back in November 2001. Froman faced both federal and state charges, with prosecutors in Harris County preparing to try him for aggravated sexual assault of a child, in addition to the federal charges related to the Candyman Group. Assistant U.S. Attorney Joe D. Orendane, handling the federal prosecution in the Southern District of Texas, told reporters that the evidence against Froman was substantial and that prosecutors were confident in securing a conviction. The Chronicle's reporting noted that Froman's alleged creation of child sexual abuse material involving a relative represented perhaps the most disturbing aspect of an already deeply disturbing case. In Baltimore, Maryland, news outlets reported on the arrest of a Catholic priest who had been a member of the Candyman Group. The Archdiocese of Baltimore issued a statement expressing shock and immediately placed the priest on administrative leave pending the outcome of their criminal investigation. We are cooperating fully with law enforcement, the Archdiocese's spokesperson told reporters. The Church takes these allegations with the utmost seriousness, and if they are proven true, appropriate canonical procedures will be followed, in addition to any criminal penalties. The arrest came at a particularly sensitive time for the Catholic Church, as the clergy sexual abuse scandal that had erupted in Boston just months earlier was continuing to expand, with revelations emerging about decades of abuse and institutional cover-ups in dioceses across the country. The Candyman case added another dimension to this crisis, demonstrating that some clergy members were not only direct abusers, but were also participants in networks that traded images of abuse. In Albany, New York, the arrest of a school bus driver sent parents into a panic. The man had driven children to and from school for years, having daily access to dozens of children whose parents had trusted him with their safety. The school district immediately terminated his employment and issued letters to parents explaining the situation. We understand parents' concerns, the superintendent told local media. We want to assure everyone that there is no evidence at this time that any of the children in our district were victimized by this individual. However, we are cooperating fully with law enforcement, and if anyone has any information or concerns, they should contact the police immediately. The statement did little to calm anxious parents, many of whom felt betrayed that someone in such a position of responsibility had been living a secret life as a consumer of child exploitation material. The case of the Las Vegas preschool teacher's aide generated similar concern. Nevada authorities reveal that the individual had worked at a licensed child care facility, interacting daily with children as young as 3 years old. The child care center immediately fired the aide and conducted an internal review of its hiring and screening practices. Parents with children enrolled at the facility were notified, and several told local news stations that they felt sick thinking about their children having been in the care of someone who participated in the Candyman group. "How does someone like that pass a background check?" one mother asked reporters. "What good are these screening systems if they can't catch these people?" Throughout late March and April 2002, prosecutors across the country began filing formal charges and obtaining grand jury indictments against Candyman subscribers. The charges varied somewhat from jurisdiction to jurisdiction, but most involved violations of federal statutes prohibiting the receipt, possession, and distribution of child pornography through interstate commerce, specifically through the Internet. Title 18, United States Code, Section 2252A, which prohibits certain activities relating to material involving the sexual exploitation of minors, formed the basis for most federal prosecutions. The statute carried significant penalties, a minimum of 5 years and a maximum of 20 years in prison for a first offense, with higher mandatory minimums for defendants with prior convictions. In the Southern District of Texas, prosecutors had assembled an especially strong case against Mark Bates himself, the creator and moderator of the Candyman group. The indictment against Bates, filed in the U.S. District Court for the Southern District of Texas, charged him with multiple counts of distribution and receipt of child pornography. The indictment detailed how Bates had created the group, recruited members, distributed surveys about content preferences, and actively facilitated the exchange of illegal material among thousands of subscribers. Prosecutors argued that Bates was not merely a passive participant, but was the architect of an international criminal conspiracy. The evidence against Bates included not only his role in creating and administering the group, but also the material found on his personal computers when agents executed a search warrant at his residence in Anderson County. Forensic examination of Bates's hard drives revealed extensive collections of child pornography, including many images that had been shared through the Candyman group, but also additional material from other sources. The prosecutor's sentencing memo would later argue that Bates possessed one of the largest collections of child exploitation material that investigators had encountered, with thousands upon thousands of images and video files cataloged and organized in folders on his computer systems. But as prosecutions moved forward, defense attorneys began mounting challenges to the cases, and these challenges exposed what would become a significant problem with many of the Candyman prosecutions. The central issue revolved around the search warrant affidavits and the probable cause used to justify searches of subscribers' homes and computers. Recall that Agent Benny's template affidavit stated that every email sent to the group was distributed to every member automatically. Defense attorneys argued that this statement was false and that the search warrants based on this false information should be invalidated, with all evidence obtained through those searches suppressed under the exclusionary rule. On April 19, 2002, defense attorney Benson Everett Woolman filed a motion in the Eastern District of Missouri on behalf of his client, Gregory Strausser, arguing that the search of Strausser's residence should be declared unconstitutional. The motion, which would become a template for similar defense motions filed across the country, made several key arguments. First, Woolman contended that the statement in the search warrant affidavit about automatic distribution of emails was materially false, according to information that defense attorneys had obtained through their own investigation of how e-groups functioned. Members of e-groups could configure their accounts in different ways. Some members chose to receive individual emails, meaning they would receive each message sent to the group as a separate email in their inbox. But other members chose alternative delivery methods, such as a daily digest, that would compile all the day's messages into a single email. Or they could choose special notices, which meant they would only receive administrative messages from the moderator. Or they could even choose web-only access, which meant they would receive no emails at all and would only access the group's content by logging into the website directly. This meant, Woolman argued, that mere membership in the Candyman group did not automatically mean a person possessed child pornography. It was entirely possible that a subscriber had configured their account for special notices or web-only access and had never actually received any of the illegal images that other members shared via email. Without knowing how each specific subscriber had configured their account settings, the FBI could not establish probable cause that a particular subscriber possessed illegal material merely because they were a member of the group. The search warrant affidavit's claim of automatic distribution to all members was therefore misleading, and Judge Binney either knew it was false or should have known it was false before including it in the template affidavit. Furthermore, Woolman argued that even if a subscriber had configured their account to receive individual emails, there was no way to know whether they had actually opened and viewed the emails containing illegal images, or whether they had deleted them without viewing them, or whether they had configured their email client to filter messages from the Candyman group into a folder that they never checked. The mere technical receipt of an email message, he contended, did not constitute possession under federal law, especially if the recipient never opened or viewed the message. The motion created serious problems for prosecutors. If courts accepted these arguments, hundreds of search warrants might be invalidated, and the evidence obtained through those searches would be suppressed, making prosecution impossible. The FBI and Justice Department found themselves in the position of having to defend not only the validity of the search warrants, but also Agent Binney's understanding of how the e-group's platform functioned and whether he had made false statements negligently or recklessly. In late April and early May 2002, government attorneys filed responses to the defense motions, arguing that even if the search warrant affidavits contained some technical inaccuracies about e-group's delivery options, the warrants were still valid under the good faith exception to the exclusionary rule. Under United States v. Leon, a 1984 Supreme Court case, evidence obtained through a search warrant later found to be defective should not be suppressed if the officers executing the warrant relied on it in good faith, believing it to be valid. Government attorneys argued that Agent Binney had acted in good faith based on his understanding of e-groups at the time, and that any inaccuracies in the affidavit were not deliberate falsehoods, but honest mistakes that did not undermine the overall probable cause showing. Moreover, prosecutors argued that the search warrant affidavits contained substantial additional probable cause beyond just the e-group's membership. In many cases, including Strausser's, the affidavits noted that the subscriber had used screen names that suggested sexual interest in children, such as Strausser's use of Little Butt Sue and Little Tit Girly. These screen names, combined with membership in a group openly dedicated to sharing child exploitation material, provided sufficient probable cause for a reasonable magistrate judge to issue a search warrant. The fact that some technical details about email delivery might have been incorrect did not negate the totality of the circumstances supporting probable cause. The legal battles over these motions would continue for months, with different judges in different districts reaching different conclusions. Some courts granted the defense motions and suppressed evidence, effectively ending those prosecutions. Other courts denied the motions, allowing the cases to proceed. The inconsistency created confusion and frustration for both prosecutors and defense attorneys, as well as for defendants who faced different outcomes based largely on which judge happened to be assigned to their case. By summer 2002, the FBI's investigation continued to expand, even as legal challenges threatened some prosecutions. In June, the Bureau announced additional arrests, bringing the total number of people charged in Operation Candyman to more than 100. The new arrests included defendants in states that hadn't been part of the initial March sweep, as investigators continued working through the list of thousands of subscribers. Some of these later arrests involved subscribers who had been more difficult to locate, having moved since their Candyman membership or having used more sophisticated methods to conceal their identities. In testimony before Congress in July 2002, FBI Director Robert Mueller highlighted Operation Candyman as an example of the Bureau's commitment to combating crimes against children in the digital age. The internet has created unprecedented opportunities for predators to access, create, and distribute images of child sexual abuse, Mueller told the Senate Judiciary Committee. Operation Candyman demonstrates that we have the capability to identify and prosecute these offenders but it also reveals the massive scale of the problem we face. With 7,000 members in just this one group, and with new groups constantly emerging, we need additional resources and continued cooperation from the technology industry to stay ahead of these criminals. Mueller's testimony came as Congress was considering enhanced penalties for child exploitation offenses and increased funding for the FBI's Innocent Images National Initiative, a program dedicated to combating child sexual exploitation facilitated by online technology. The revelations about Candyman's scope and the discovery that many subscribers held positions of trust in their communities added urgency to these legislative efforts. By September 2002, Congress would pass the Prosecutorial Remedies and Other Tools to End the Exploitation of Children Today Act, known as the PROTECT Act, which enhanced penalties and provided additional tools for prosecuting child exploitation cases. On November 15, 2002, Mark Bates appeared in federal court in Houston for his sentencing hearing after pleading guilty to multiple counts of child pornography distribution and receipt. The courtroom in the Bob Casey United States Courthouse was filled with federal agents who had worked on the investigation, prosecutors who had built the case, and a few members of the media who had followed the Candyman story from its initial public revelation. Judge Kenneth Hoyt, a respected jurist with decades of experience on the federal bench, presided over the proceeding. Assistant U.S. Attorney Joe Orendane presented the government's sentencing recommendation, arguing for a substantial prison term that would reflect the severity of Bates's crimes and his role as the organizer of the Candyman group. Orendane detailed for the court how Bates had not merely participated in an existing criminal network, but had created one, had actively recruited members, had surveyed them about their preferences, and had facilitated the distribution of thousands of images depicting the sexual abuse of children to thousands of recipients around the world. The defendant created what amounted to an international marketplace for the exploitation of the children. He brought together individuals who shared his deviant interests and provided them with a platform to feed their addictions and enable their criminal behavior. The harm he caused is incalculable, not only to the children depicted in the images, but to every member of society who has an interest in protecting the vulnerable among us. The prosecutor also emphasized Bates's prior convictions for child molestation, arguing that these demonstrated a pattern of predatory behavior spanning years. This is not someone who made a one-time mistake or who acted impulsively, Orendane continued. This is someone with a documented history of sexual offenses against children who, when given access to internet technology, used it to create the largest child pornography distribution network that we had encountered at that time. He poses a serious danger to children, and only a substantial prison sentence can adequately protect the public and provide just punishment for these crimes. Bates's defense attorney offered little in mitigation, acknowledging the severity of the offenses and his client's history. The defense's primary argument focused on Bates's difficult personal circumstances, his unemployment following the truck accident, and the isolation he experienced living with his parents in rural East Texas. The attorney suggested that Bates had turned to the internet as an escape from his troubles, but had become consumed by his addiction to child pornography. While not excusing the behavior, the defense asked the court to consider these factors in fashioning an appropriate sentence within the federal sentencing guidelines range. Judge Hoyt listened carefully to both sides before pronouncing sentence. The judge noted that the federal sentencing guidelines, combined with Bates's prior convictions and his role as an organizer of criminal activity, called for a significant prison term. Mr. Bates, Judge Hoyt addressed the defendant directly. You created a network that facilitated the exploitation of children on a massive scale. Every image depicts a real child who suffered real abuse. Every person who views these images perpetuates that abuse and creates demand for new images, leading to new victims. Your actions have caused immeasurable harm. Judge Hoyt sentenced Mark Bates to 30 years in federal prison, one of the lengthiest sentences handed down for child pornography offenses at that time. The sentence reflected not only the volume of material Bates possessed and distributed, but also his role as the organizer and moderator of the Candyman group. With federal good time credits, Bates would serve approximately 25.5 years before becoming eligible for release. Following his prison term, he would be subject to lifetime supervised release, during which he would have no unsupervised contact with minors and would be subject to computer monitoring and other conditions designed to prevent recidivism. The sentence sent a strong message to others who might consider creating similar networks. In the months following Bates's sentencing, other Candyman prosecutions proceeded through the courts with varying outcomes. Robert Froman, the Pasadena bunkhouse manager, pleaded guilty to federal charges in March 2003 and was sentenced to 15 years in federal prison. The state charges against him for aggravated sexual assault of a child were prosecuted separately, resulting in an additional lengthy prison term to be served consecutively. Froman's case was particularly significant because it demonstrated that some Candyman subscribers were not merely consumers of abuse imagery, but were themselves producing new material by abusing children in their care. The case of Gregory Strausser in Missouri took a different path due to the legal challenges his attorney had raised. In December 2002, U.S. District Judge Donald Storr held a hearing on Strausser's motion to suppress evidence obtained during the search of his residence. The hearing focused on whether Agent Binney's statements about e-groups' automatic email distribution were materially false and whether, if false, they invalidated the search warrant. The government called Agent Binney to testify about his investigation and his understanding of how e-groups functioned. Under questioning from Assistant U.S. Attorney Robert Steele, Binney explained that his investigation of the Candyman group had been conducted in early 2001, shortly after the group was created. At that time, based on the way his own subscription functioned and based on information available about e-groups, he believed that all members received all emails sent to the group. When I subscribed and began receiving emails, Binney testified, I received hundreds of messages over the course of several weeks. Based on my training and experience with similar platforms, and based on how the group appeared to function, I understood that this was how e-groups operated for all members. On cross-examination, defense attorney Woolman pressed Binney about whether he had actually verified his assumptions about e-groups' delivery options. Had he reviewed e-groups' help documentation? Had he contacted e-groups directly to ask about delivery settings? Had he examined the account settings for specific subscribers to determine how they had configured their accounts? Binney acknowledged that he had not taken these additional steps. At the time, Binney explained, I was focused on identifying subscribers and gathering evidence about the material being distributed. The way I understood the platform to work, membership itself was strong evidence of receipt and possession because all members were receiving all emails. Woolman then introduced evidence showing that e-groups offered multiple delivery options and that different members could choose different settings. He produced declarations from computer forensics experts explaining how the various delivery options worked and arguing that without knowing each specific subscriber's settings, it was impossible to establish that they had actually received emails containing illegal images. The hearing concluded with Judge Storr taking the matter under advisement, promising a written decision in the coming weeks. On January 17, 2003, Judge Storr issued his decision denying Strausser's motion to suppress. In a detailed written opinion, the judge acknowledged that Agent Binney's search warrant affidavit contained some technically inaccurate statements about e-groups' delivery mechanisms. However, Judge Storr concluded that these inaccuracies did not rise to the level of deliberate falsehoods or reckless disregard for the truth. The evidence shows that Agent Binney acted based on his reasonable understanding of the platform at the time, the judge wrote. While he could perhaps have taken additional steps to verify every technical detail, his failure to do so does not demonstrate the kind of intentional or reckless falsity that would warrant suppression of evidence. Moreover, Judge Storr found that even if the problematic statements about automatic email distribution were removed from the affidavit, sufficient probable cause remained to support the search warrant. Strausser's use of screen names like Little Butt Sue and Little Tit Girly, combined with his voluntary membership in a group that openly trafficked in child exploitation material, provided adequate grounds for a reasonable magistrate to conclude that evidence of crime would likely be found at Strausser's residence. Under the totality of the circumstances, Judge Storr wrote, probable cause existed independent of any technical inaccuracies regarding email delivery methods. Finally, the judge held that even if the warrant had been defective, the good faith exception would apply. The officers executing the search warrant had no reason to doubt its validity, and suppressing the evidence would serve no deterrent purpose since the officers had relied in good faith on a warrant issued by a neutral magistrate. The decision cleared the way for Strausser's prosecution to proceed. In March 2003, facing overwhelming evidence, including his own admission to agents that he possessed thousands of child pornography images, Strausser pleaded guilty and was sentenced to 5 years in federal prison, a relatively lenient sentence compared to Bates due to Strausser's lack of prior criminal history and his role as a subscriber rather than an organizer. Similar legal battles played out in courts across the country throughout 2003 and 2004. In the Western District of Pennsylvania, U.S. District Judge Donetta Ambrose granted a defense motion to suppress in United States v. Blakey, finding that the affidavit's misstatements about e-groups were material and that insufficient probable cause remained after excising the false information. The defendant in that case walked free, with prosecutors unable to proceed without the suppressed evidence. In contrast, Judge Jack Weinstein in the Eastern District of New York denied a motion to suppress in United States v. Perez, reaching conclusions similar to Judge Storrs and allowing that prosecution to proceed. The inconsistent outcomes frustrated everyone involved in the cases and highlighted the complexities of applying traditional Fourth Amendment doctrine to novel technologies and investigative techniques. By late 2003, the FBI announced that Operation Candyman had resulted in more than 100 convictions through guilty pleas or trials, with additional cases still pending. The operation had led to the rescue of several children who were being actively abused by Candyman subscribers, including the relative whom Robert Froman had victimized, and children in at least 4 other households, where subscribers had been producing new material. The investigation had also generated intelligence that led to other operations, as seized computers often contained evidence linking defendants to additional networks and groups beyond Candyman. The international dimension of Operation Candyman continued to develop as well. By early 2004, law enforcement agencies in at least 20 countries had made arrests based on information provided by the FBI about foreign Candyman subscribers. In the United Kingdom, Operation Or, a massive investigation into child pornography that had begun independently of Candyman, intersected with the American investigation when British police discovered that several of their targets were also Candyman subscribers. Similar intersections occurred in Canada, Australia, Germany, and several other nations, demonstrating that child exploitation networks often had overlapping memberships and that international cooperation was essential for effective enforcement. In Canada, the Royal Canadian Mounted Police announced in February 2004 that Operation Candyman information had led to charges against more than 40 Canadian residents. The RCMP's Integrated Child Exploitation Unit executed search warrants across several provinces, seizing computers and arresting individuals who had been members of the Candyman group. Among those charged were teachers, coaches, and other individuals in positions of trust, mirroring the patterns seen in the United States. The exploitation of children knows no borders, RCMP Superintendent Dave Hall told reporters. These networks operate internationally, and our response must be international as well. The cooperation we've received from the FBI and from our international partners has been invaluable. In March 2004, the U.S. Department of Justice held a press briefing to mark the second anniversary of the Operation Candyman announcement and to provide updated statistics on the investigation's outcomes. Deputy Attorney General James Comey, who had succeeded Larry Thompson in December 2003, presided over the briefing along with FBI officials. Comey announced that Operation Candyman had ultimately resulted in the identification and investigation of over 2,700 suspects in the United States alone, with prosecutions filed against more than 140 individuals. The investigation had generated more than 1,500 leads that were forwarded to state and local law enforcement agencies for cases that didn't meet federal prosecution thresholds but could potentially be prosecuted under state laws. Comey emphasized that Operation Candyman represented just one battle in an ongoing war against child exploitation online. For every network we dismantle, others emerge, he said. The technology continues to evolve, with predators moving to more sophisticated platforms, using encryption, operating on what's called the dark web, where sites are hard to trace. We must continue to invest in training, technology, and international cooperation to stay ahead of these criminals. The Deputy Attorney General also addressed some of the legal challenges that had complicated certain prosecutions, acknowledging that courts had reached different conclusions about the validity of search warrants in Candyman cases, but expressing confidence that the vast majority of convictions would withstand appellate scrutiny. We've learned important lessons about how to investigate these cases, how to draft search warrant affidavits, and how to work with technology companies to obtain accurate information about how their platforms function, Comey stated. These lessons are being incorporated into FBI training and will strengthen future investigations. At the same briefing, FBI Assistant Director Michael Mason announced a new initiative called Operation Predator Protection, which would build on the lessons learned from Candyman and focus on proactive identification of child exploitation networks before they could grow to the size and scope that Candyman had reached. Our goal, Mason explained, is to identify these networks early, infiltrate them, map out their membership, and take them down before thousands of people are involved and before massive amounts of material can be distributed. We're also working more closely with technology companies to ensure that their platforms are not being exploited for these purposes. Throughout 2004 and 2005, several Candyman defendants who had pleaded guilty or been convicted at trial began filing appeals, challenging various aspects of their prosecutions. The primary grounds for appeal included the Fourth Amendment issues regarding search warrant validity, First Amendment challenges, arguing that simple possession of images should be protected speech, arguments about whether the government had proven the images depicted actual children rather than computer-generated images, and sentencing challenges, arguing that the federal sentencing guidelines produced excessive sentences. The First Amendment claims were uniformly rejected by appellate courts, which followed Supreme Court precedent established in New York v. Ferber and Osborne v. Ohio, holding that child pornography has no constitutional protection. The Ninth Circuit Court of Appeals in United States v. Worley summarized the reasoning. The prevention of sexual exploitation and abuse of children constitutes a government objective of surpassing importance. The use of children as subjects of pornographic materials is harmful to the physiological, emotional, and mental health of the child. Courts held that this compelling government interest justified criminalizing the possession and distribution of child pornography, with no First Amendment protection applying. Challenges based on whether images depicted actual children had more mixed results. The Supreme Court in Ashcroft v. Free Speech Coalition had held in 2002 that computer-generated images that appeared to depict children but did not involve actual children could not be prohibited under the First Amendment because no actual child was harmed in their creation. This meant that in Candyman prosecutions, the government had to prove that images depicted real children, not virtual ones. In most Candyman cases, this was not difficult because the images were clearly photographs or videos of actual children. However, in a few cases where defendants possessed more ambiguous images, courts required the government to present expert testimony or other evidence establishing that the images depicted actual minors. The Fourth Amendment challenges produced the most varied results on appeal. The Third Circuit Court of Appeals in United States v. Cobb affirmed the denial of a motion to suppress, despite acknowledging inaccuracies in the search warrant affidavit about E-Group's email delivery system. The court held that the good faith exception applied and that sufficient independent probable cause existed based on the defendant's screen names and voluntary membership in the Candyman group. However, the Ninth Circuit reached a different conclusion in United States v. Hay, reversing a conviction and holding that the affidavit's misstatements were material and that insufficient probable cause remained after excising them. The Hay Court emphasized that the government bore a heavy burden when seeking to search someone's home and could not cut corners in establishing probable cause. These conflicting appellate decisions created a circuit split, and legal scholars predicted that the Supreme Court might eventually need to resolve the disagreement. However, the court declined to grant certiorari in any of the Candyman cases, leaving the circuit split unresolved and allowing different constitutional standards to apply in different parts of the country. This outcome was unsatisfying from a legal perspective, but reflected the court's reluctance to wade into the complex, factual questions about internet technology and investigative techniques that these cases presented. By 2006, most of the Candyman prosecutions had concluded, with defendants either having exhausted their appeals or chosen not to appeal. The operation's final statistics were impressive by any measure: more than 160 successful federal prosecutions, dozens of additional state prosecutions, hundreds of cases investigated and referred to state authorities, and arrests in more than 20 countries based on FBI-provided information. The investigation had resulted in the seizure of millions of images and videos depicting child sexual abuse, representing countless victims whose exploitation had been documented and traded within the Candyman network. Perhaps more importantly, Operation Candyman had demonstrated that large-scale international child exploitation networks could be successfully infiltrated and dismantled through coordinated law enforcement action. The investigation had required unprecedented cooperation between federal, state, local, and international law enforcement agencies, as well as cooperation from internet service providers and technology companies. It had pushed FBI investigators to develop new techniques for tracing online identities, conducting computer forensic examinations, and managing massive data sets containing thousands of leads and suspects. The operation also had broader cultural and policy impacts. Media coverage of Candyman and similar cases raised public awareness about child exploitation on the internet and generated support for stronger laws and increased funding for investigations. Parents became more aware of online dangers and more vigilant about monitoring their children's internet use. Schools began implementing internet safety curricula. Technology companies faced pressure to implement better safeguards against the misuse of their platforms. In Congress, Operation Candyman was frequently cited during debates over legislation aimed at combating child exploitation. Senator Orrin Hatch of Utah, chairman of the Senate Judiciary Committee, referenced Candyman extensively during hearings on the PROTECT Act in 2003. The Candyman case shows us both the scale of the problem we face and the effectiveness of law enforcement when given adequate tools and resources. Hatch told his colleagues, "We must ensure that our laws keep pace with technology and that we provide the FBI and prosecutors with everything they need to protect children in the digital age." The PROTECT Act, which became law in April 2003, included several provisions directly influenced by Operation Candyman. It enhanced penalties for child pornography offenses, created a new offense for advertising or seeking child pornography, eliminated certain affirmative defenses that had allowed some defendants to escape liability, and provided additional resources for the FBI's Innocent Images program and for the National Center for Missing and Exploited Children's cyber tip line. In 2007, 5 years after the initial Operation Candyman announcement, several news organizations published retrospective articles examining the operation's long-term impact. The Houston Chronicle, in a detailed investigative piece published in March 2007, tracked down several of the Texas residents who had been prosecuted as part of Candyman and examined what had happened to them. Mark Bates remained incarcerated at a federal prison facility, serving his 30-year sentence with more than 2 decades still remaining. Robert Froman was serving his combined federal and state sentences and would not be eligible for release until he was well into his 70s. Other defendants had completed shorter sentences and were living on supervised release, subject to strict conditions including sex offender registration, computer monitoring, and prohibitions on contact with children. The Chronicle's reporting included interviews with family members of some defendants who described the devastation that the arrests and prosecutions had caused. "Our family was destroyed," the sister of one convicted Candyman subscriber told the newspaper. "We had no idea what he was doing. When the FBI showed up at his house, we couldn't believe it. Even now, years later, we're still dealing with the shame and the questions from neighbors and people in our community." Other family members expressed anger at the defendants themselves, feeling betrayed and horrified by what their relatives had done. "I can never forgive him," one mother said of her son who had been convicted. "What he participated in, those were real children suffering real abuse. I don't understand how he could have done that."